I'd like to introduce our last panel and our keynote speakers. Kristen Snyder, she's from the SEC, and if you can please introduce your colleagues, and thank you.
Yeah, thanks. And before I make any introductions, I have to give a standard disclaimer that all SEC speakers have to give, and so I will give it once so we don't have to do it 4 times. But that is that the remarks that all of us make are our own. They don't necessarily reflect the viewpoints held by our colleagues on the commission staff, the SEC, or SEC commissioners. So with that out of the way, I'll do a quick introduction of the panelists. I have a few opening remarks, and then we'll kick it off. Right next to me is Victor Hong. Victor is in our Division of Enforcement in the San Francisco office, so you probably don't want to see Victor outside the context of this panel today. Next to Victor is Scott Walker, and both Scott and I are in the Office of Compliance Inspections and Examinations at the SEC, also known as the National Exam Program. So we are often interacting with folks in the ICO space or distributed ledger technology space through exams of exempt reporting advisors or registered investment advisors. And then the giant head on the screen, and full disclosure, Zach, you are giant on the screen. Yep. It's Zach Fallon, who is a special counsel in our Division of Corporation Finance. And both Scott, Victor, and I are resident here in the San Francisco's office. Most of our regions have both enforcement and exam. Our policy divisions are all located in Washington, D.C., so Zach was kind enough to join us remotely today. We're really excited to be here. We want to thank Blockchain at Berkeley for inviting us to participate today. Both Scott and Nadia Brannon, who's in the audience from our exam program, attended an event that Blockchain put on in the recent past, and we're very impressed. And so, again, we're just very excited that we're here listening to what you have to say today, as well as being able to share. I think ICOs, virtual currencies, distributed ledger technology, these are all new and emerging areas for us as well. And so it's incredibly helpful when we can engage and hear industry perspectives. It helps us to be a better, smarter regulator. And we are definitely trying to balance our investor protection mission, which is very important. It's one of our core missions, against the also important mission to help facilitate capital formation. And as regulators, we're really trying to get the balance right. And again, hearing your feedback and engaging in dialogue like this is extremely helpful. I wanted to plug one resource for you. I think you'll hear it maybe a couple of times on the panel, and then also to do some level setting. We heard some of the panels today. I think there are a range of experiences in the room, is my understanding from talking to Ronan. So some folks are very well versed in the law and the SEC regulatory structure. Others are well-versed in the technology. And so I think what we intend to do is just to provide an overview of sort of the path to capital formation if you're accessing or if you're offering or selling securities, and just talk about the SEC's regulatory framework, also talk about some of the guidance that the SEC has issued in the ICO space. Talked about the Dow report on some of the other panels. I think we'll highlight some of our takeaways from that report as well. And then you have Zach, who was really a key architect and instrumental in drafting some of the regulations that now exist as part of the Jobs Act. So we really encourage you to ask questions. Some of the questions I think we will be able to answer. Others, because this is an emerging area and we want to be very deliberative and careful in terms of the type of guidance that we're giving, we may not be able to answer, but hearing your questions is helpful. Okay, and so then my plug is that we have a fintech@sec.gov mailbox. It's monitored by our policy divisions, and so we are pretty frequently getting questions in from the industry on all issues related to fintech, and it's a way for us to, we can't give advice, it's a way for us to hear your concerns and potentially get guidance out. So we would just encourage you to write in. That's fintech@sec.gov. And the more detailed that you can be in your question, I think it can be helpful to us in answering those questions.
Yeah, I'd just like to add to that I think it's a good forum to do a deeper dive into fact-specific issues that you may have or you may be contemplating. But before we go further, I'd just like to kind of take the temperature of the room. Could you guys raise your hands if you are your developers or engineers? Okay. For context, Zach, that is a significant portion of the room. Now, could you raise your hands if you are only investors in this space? There's one guy. Oh, all right, 2 guys. All right, thank you. No, that helps us kind of craft the direction of this conversation.
Okay, so I think we're going to kick it off with Victor, who's going to talk about the Dow report that I know was covered also on the legal panel. But I think just hearing from the SEC's perspective, some of the takeaways would be helpful.
Sure. Thanks, Kristen. I really enjoyed the opportunity to engage with the community on a more informal basis. And so the Dow report was issued by the Commission over the summer. The takeaways from me are, number one, that I think the Commission recognizes that ICOs can provide a fair and lawful way to invest, but that although it's a new technology and is arguably a new financial instrument, that current federal securities laws may apply to it if the circumstances are appropriate. And we tried to lay that out in the Dow report. I guess that's the first takeaway, is that the analysis is not a bright line. It's going to be case by case. And we try to flesh it out by pointing back to the Supreme Court case in Howey, which defined investment contracts. And just as a background, just step back, securities are defined by statute. And there's a list, basically there's a list of different types of instruments, stocks, bonds, and so on. There's about like a dozen or so, one of which is an investment contract. So that's how we get here. You have a number of different instruments, one of which is an investment contract. Now, the investment contract is one of the broader, sort of almost like a catch-all portion of the definition of securities. But it's fleshed out in a multi-part test by the Supreme Court. Without dwelling too much on the details of it, first, there's an investment of money, 2, in a common enterprise, 3, with the expectation of profit, 4, derived from the efforts of others. So that's sort of the touchstone of what is an investment contract, and therefore, in turn, what is a security. And so that's sort of the second thing is, that's probably the litmus test you guys want to understand and apply to your particular situation. Are those factors, how do they apply to how you're structuring your issuance? Now, what happens if, under the Howey test, what the token that you're issuing is a security? Well, the main ramification of that is that the token would have to need to be registered with the SEC, so that would mean providing a lot of disclosure, and there would be review by the Commission to ask questions about various aspects of your disclosure, and that unless there's a valid exemption from registration, that's the next step you would need to take. But you would still raise your money, you just have to do it by registering, unless an exemption applies.
Can I jump in real quick? I just want to point out, with respect to registration, just again to kind of level set, the process is really, in terms of the regulatory framework, it's comprehensive in that it's an attempt to assure that investors have material facts in connection with the offering or the security. It's not a merit-based kind of view. So in other words, the Commission is not effectively saying this is going to be a successful investment or this is going to be an unsuccessful investment or anything of that nature. It's really just the driver here is simply that investors or prospective investors have transparency into what they may be purchasing. And I think that that's kind of well aligned with a lot of what we're hearing here today, and in terms of what we're hearing, just generally speaking, with respect to the view of the ecosystem at large.
Okay. And so I guess the final takeaway for me is that if you are issuing a security, there's, I guess you guys would call it an ecosystem. There is a number of market participants sort of that are involved in the sale or custody of securities, and those people have obligations under the securities laws, which we can talk about in a little more detail. But the Dow report did specifically talk about the possibility that platforms that provide for trading in these I would call them maybe crypto securities or virtual securities need to register with the SEC as a national securities exchange or operate with an exemption from registration. And we did hear earlier panels talk about the fact that there are a number of issuances out there that sort of look like they're fraudulent. We in enforcement are aware of those, and we'll talk about this again in a little more detail, that we are very interested in getting to the bottom of those, and the chairman himself has said that this is a very important area to him.
Yeah, so Victor, you touched on a moment ago, in addition to issuers, having to think about regulations and registration, that there may be other market participants where if they're facilitating the sale of a security, for instance, or in other aspects are interacting with the security, that they may need to think about the SEC's regulatory framework. Can you talk about that?
Oh, sure. So some of the main market participants are brokers, and those are people who sell or purchase securities on the behalf of others. Dealers, those are people who do the same thing but on their own behalf, their own account, and investment advisors, people who give investment advice for compensation. So those are three main areas where in the securities world that sort of predated the ICO phenomenon are regulated by the SEC. So in aspects such as how quickly you have to execute a trade, when do funds have to transfer after the exchange of a security, separate, and a very important one, a custody rule, segregation of the customer's assets from the company's assets. So if the company goes under, the customer's assets don't go down with the company in a bankruptcy. So those are areas where if the token issuance is a security, those provisions could be implicated.
Okay, and I think we'll switch gears since we have Zach on the screen, and we'll invite, rather than waiting to the end, if you have questions, particularly in sort of the capital raising framework space, so Reg A Plus or any of the rules that Zach is going to talk about, we'd welcome those questions. But Zach, can you just kind of generally or briefly go over some of the exemptions from registration that may be relevant in this space?
Thanks, Kristen, and thank you to Blockchain at Berkeley for being able to dial me in, Alex on the AV team, and the others, and Ronan as well. I do appreciate it. I'm sorry that I couldn't be there in person, and also thank you for all of you for coming to the event, because frankly, the very fact that you're there means you're thinking about these issues, which is a good thing to do, because as you raise capital, the securities laws should always be somewhere in your mind. So that the fact that you're there is a good thing, asking and hearing the right questions and answers. As Kristen mentioned, I work for the Commission's Division of Corporation Finance, and more specifically, I'm a counsel in the Office of Small Business Policy. We write, interpret, and provide guidance on a number of rules that relate to smaller companies and capital formation generally. We also respond on a daily basis to questions from market participants that on the federal securities laws. And for example, last year we responded to over 1,700 questions from people like yourselves, or lawyers, accountants, people trying to navigate the securities laws and see what their options are. So one takeaway should be that we certainly are here to help to the extent we can provide answers. So I'm going to briefly cover the capital raising framework through the offer and sale of securities, with a particular emphasis on our exemptions from registration. As Kristen said, if you're going to offer and sell a security, you need to focus first on the basic premise of the Securities Act of 1933, and that statute being foundational to the work we do. Now, the basic premise is that every offer or sale of securities needs to either be registered with the SEC or conducted pursuant to an exemption from registration. You've probably heard that before. It won't be the last time you hear it. It's sort of a tenet to remember with the securities laws, because thinking of it reminds you of how broad the application of the securities laws could potentially be. There are many different exemptions from registration, so all is not lost by someone saying it's a security. There are exemptions, and there's flexibility within the regulatory regime to accommodate different types of offerings. I'll give you a brief overview of some of those, but rather than start with discussing the requirements of each exemption separately, I think it's generally helpful to ask a threshold question, the answer to which can drive you to one exemption or another. And the basic question is, does the business know accredited investors or sophisticated investors that would like to invest in it? Accredited investors being a defined term of an investor that meets certain specified income, net worth, or total asset thresholds for individuals. and sophisticated investors having the knowledge and experience to evaluate the merits and risks of an investment. If the answer to that is yes, then you may want to consider relying on what's commonly known as the private placement exemption, and that is conducted pursuant to Section 4A2 of the Securities Act. More commonly relied upon is a safe harbor under that section, which is Rule 506B. That is the Rule 506B is the most common exemption relied upon by issuers. Some things to note about Rule 506B offerings is that the issuer can't generally solicit or advertise the offering. So you can't be out there, telling people willy-nilly about you trying to raise money and sell securities. You need to, as a sort of a rule of thumb would be, do you have a pre-existing substantive relationship with these people? If so, then you can certainly tell them about it. There's no general solicitation issue there. So to the extent you avoid general solicitation, pursuant to Rule 506B, there's no limit on the amount of money you can raise, and there's no limit on the amount of money that an individual can invest in the deal. If you're going that route and you sell to only accredited investors, you don't really have any substantive disclosure requirement either. But if you do want to sell to non-accrediteds who are sophisticated, you can sell up to 35 of those types of people. If you do that, you have to provide them with some disclosure, including financial statements. You also have to file a Form D, which is really a notice form, pretty basic, with the SEC. And importantly, the securities that are sold pursuant to 506B offerings are restricted securities, and that is for purposes of resale. There are limitations on the ability to resell those in the near term generally. You don't have to worry about state securities laws substantively regulating the offering. You do, however, have to sort of accommodate state regulators by filing the Form D with them and paying certain fees with them. But presumably because not everyone knows accredited investors or sophisticated investors, or they are unable to generally raise enough money from those types of people to the extent they do know them. Congress in 2012 passed what was called the Jumpstart Business Startups Act, or the Jobs Act, that laid the groundwork for several new exemptions that were designed really to help smaller companies raise capital without having to really fully register with the SEC. These are often referred to as crowdfunding, but there's no real ownership on the term crowdfunding. So these exemptions typically are, from a regulatory standpoint, are Rule 506C offerings, or regulation crowdfunding offerings, which is an actual term, and Regulation A offerings. I think you've spoken about some of those earlier today, and I apologize I wasn't online then, but you may have some familiarity with them. On those types of exemptions, Rule 506C is largely based on Rule 506B, the difference being that you can generally solicit or generally advertise to potential investors. So you could actually reach out to people you don't know there. The catch is that if you go that route, you have to sell to accredited investors only. So your pool of potential investors is more limited, but you can potentially find more of them. So that's a good thing, but that's sort of the cost of it. You additionally have to take the issuer has to take reasonable steps to verify the accredited investor status of the purchasers in a Rule 506C offering. Similar to Rule 506C, there's no limit on the amount you can raise, no limit on the amount people can invest. There's no substantive disclosure requirement because you're only selling to accredited investors. You do still have to file a Form D notice form with us and the state securities regulators. Your securities, as with 506B offerings, are restricted for purposes of resale. And again, state law is preempted from substantively regulating your offering. So separate from Rule 506C and 4A2, we have Regulation Crowdfunding and Regulation A, each of which permit issuers to raise capital over the internet from anyone, from non-accredited and unsophisticated investors or accredited investors, whomever wants to invest. Regulation crowdfunding itself is limited to capital raise of up to $1,070,000 in a 12-month period or annually. The offering on a regulation crowdfunding offering also has to happen online be conducted by a registered intermediary, registered with the SEC, that is, and FINRA, and that's typically a broker dealer or a new type of intermediary, called a funding portal. Investors in these types of deals are subject to investment limits based on a percentage of the lesser of the investor's income or net worth. Issuers also must file a substantive disclosure document with the SEC, including financial statements. And this document must also be provided to the intermediary, the funding portal that is, before you solicit interest in the offering. So that's important because if you're contemplating a regulation crowdfunding offering, you can't be out there offering until you've actually filed something with the SEC or the intermediary.
Zach, can I ask you a quick question?
Yeah, sure.
It might be helpful to talk a little bit about the financial statements, given the ICOs may have no financials.
Yeah, sure. So the financial statements, first off, depending on how much you raise, the rules themselves require different things with respect to the financial statements. So if you are raising less than, I think it's $100,000. I could be wrong on that. I don't have it in front of me. But if you're raising up to $100,000, the financial statements themselves can just be certified by the principal executive officer of the issuer. If you're raising up to $500,000, they can be reviewed or audited, depending on reviewed, but not necessarily audited. And actually, it's up to $1 million for the first time you raise. But if you raise subsequently, anything above 500 needs to have audited financial statements. So, as a out-of-the-box company, you may not have much in the way of financials to report. Doesn't mean you don't need to file financial statements saying as much. They need to be in there, but they may, frankly, be a zero balance sheet if you're just out of the box. So it's not necessarily it's not as high a threshold for a startup as some may think, but they do have to be there, and the rules sort of specify what has to go in them. So just moving on, the requirement that the offering has to happen through an intermediary limits the ability of issuers to make offers generally outside of the platform. If you're gonna be doing a reg crowdfunding offering, you can make offers off of the platform, but they're generally limited to tombstone type advertisements. Like, this is the security, this is how much we're raising, that type of thing. When you're on the portal, however, it's sort of the blessed ecosystem, so you can communicate more freely on the portal itself. A few more things to note on reg crowdfunding, and then we'll get to Reg A, is that if the securities are sold in a reg crowdfunding offering, issuers have to file annual reports. And generally, as with 506B offerings, the securities can't be resold for 1 year. There are some exceptions, which we can get into later if need be. Lastly, on reg crowdfunding, the state law is again preempted from regulating the offering substantively. Now moving on to Reg A, and then we can certainly, if there's questions, we can talk about after I just mentioned a few brief things on Reg A. Reg A permits issuers to offer up to $20 million in what is called a tier 1 offering annually. That can happen $20 million annually, or up to $50 million in a tier 2 offering annually. One of the great benefits of Regulation A is the ability to test the waters before and after, or after you file an offering statement. And testing the waters is basically your ability to go out there and make offers, to solicit interest in an offering, to determine whether there's interest, and if perhaps there isn't, then to figure out, well, I got to figure something else out. Or if there is a significant interest, to take that interest and say, okay, well, this is great. I'm gonna go with a Reg A offering, and we'll file and move forward because people seem to really want it. Careful, of course, as to how much the conversion rate between the interest and the actual investment. But putting that aside, it is helpful to sort of take the temperature of the market before you spend a lot of money potentially preparing a substantive disclosure document. So if you do pursue the offering, you have to file a substantive disclosure document with us on what is called a Form 1A. This document includes financial statements. Again, in a tier 2 offering, so the larger of the two, those financial statements have to be audited. And to Scott's point, again, if you're an out-of-the-box company, you may not have much in the way of financials. It doesn't mean you don't have to have them audited. I mean, even if you have a zero balance sheet, you still, as a regulatory exercise, need to go to someone and they need to audit that. They need to provide the opinion in a tier 2 offering that they are in fact audited, and it is in fact a zero balance sheet company. The filing of a Form 1A, the offering statement, is subject to SEC staff review and qualification before you can make sales. So you can gather interest and everything's subject to the anti-fraud laws, but you can certainly talk to people about the offering and see what takes people's temperature on it, and provide them with the disclosure that is preliminary before qualification. But you can't actually make sales until the SEC qualifies the offering. That's important. In Tier 1 offerings, state securities regulators do review the document substantively. So that's a big difference between Tier 1 and Tier 2. Tier 2, state law is preempted. Tier 1, it is not. So if you do a Tier 1 offering of up to 20 million, you're going to have to deal with the states as well. If you're doing like a national Tier 1 offering, you're going to have to be dealing with a bunch of states, right? If you're doing a very local Tier 1 offering, then you'd potentially only have to deal with, say, if you're in California doing an offering just to California, you'd have to deal with the SEC and California, though, still in a Tier 1. With Tier 2, just the SEC. You do, as with the Form D filings for private offerings, you do still have to file with states and maybe pay some fees associated with the offering, but they're not going to be reviewing and commenting on it.
Zach, could you give us some sense of how thorough the review or onerous the review process is in connection with a Reg A versus like a normal registration?
Sure. You have the same people and the same subject matter experts looking at the documents as you would with a registered deal. There's no difference in sort of the manpower dedicated to a Reg A offering versus a registered offering. The staff is, however, aware that this is an exemption from registration when they're reviewing it. And they also are aware that these are offerings that are, these are smaller offerings, frankly. So they factor those two things into account. They take them into account when reviewing and commenting on the offerings. So same people, but what we've seen is that the staff has been pretty good at tailoring their reviews for the type of offerings we're talking about, keeping in mind that the basic premise under the Jobs Act that we're trying to encourage companies to come in and display themselves publicly and to get the information out there to investors. All these things sort of enter into the calculus of the division as they look at these offerings. It doesn't mean you won't get comments, because you in all likelihood will on your document, but the touch they put on them is more appropriate, I should say, for what is actually happening with a Reg A offering.
And given that this world is moving very rapidly, could you give us some sense of timeline in terms of turnaround time?
Sure. Yeah. If you once you file a document with us, as I said before, you can go out there and gather interest. There's no need to file. You can walk away if there's no interest. You can walk away if there is interest. But as soon as you file the document, it has to be filed electronically with us. There's an online system, Edgar, that takes in filings generally, and this one is no exception to that. The review process, the staff typically, as with registration statements, tends to get back to companies within 30 days or 20 business days is the first turnaround. And then thereafter, a lot of it is going to depend on the issuer's ability to respond to the comments. So it's hard to do averages once you get a first round of comments, because people digest them differently, and they may not appreciate what the staff is asking for. One important thing is stay in communication with your examiners. If you have questions, they're people just like everyone else, and they want to help companies and get the review right. The very last thing, Scott, I'll just mention quickly with Reg A securities is a big difference between those and those issued in private placements or reg crowdfunding is that Reg A securities, like registered securities, are not restricted securities. So they are, once an investor purchases them, they are generally freely tradable after the fact. Certain, things down in the weeds which could trip people up, but for the most part, that's a general rule.
And let's compare and contrast that liquidity with like a 506C offering.
Sure. Well,
on a resale.
On a resale, well, from an informational standpoint, so Reg A, the fact that you have an information document that's been reviewed and qualified by the staff, there is a rule with respect to broker dealers anyway that they can start quotations on a Reg A offering immediately based on the offering document that was qualified by the staff. So those quotations for Reg A securities could start to happen over the counter based on a rule that's called 15C211 and the ability of brokers to rely on that to start quotations. And that's not necessarily true with Rule 506 offerings in particular, because they're restricted in the near term from resales. But is that sort of what you're asking about, Scott?
Yeah, no, that's exactly right. Thanks.
Sure. And those are generally the exemptions. There are other ones for intrastate offerings, so offerings that happen solely within the borders of a given state. We have a new exemption on that, Rule 147 Cap A, which allows people to communicate more broadly over the internet or online, so long as they sell to people only in the state in which they are located. So there's that rule as well, but you have to deal with the states on that one.
I don't know how relevant that is for this crowd.
Yeah, exactly. It may not necessarily be relevant, but unless everyone there is, in Berkeley, and those are the only people who are going to invest, and they all live there.
Yeah, and I think that was a lot of information. And so you can always, there are a number of resources that you can go to on our sec.gov website. Corporation Finance has its own page with a lot of information kind of detailed out on all of those different offerings. And I think we were also heartened to hear on the legal panel and other panels that folks, the conference are taking these issues very seriously and carefully. And so I know that you're engaging outside advice, and we certainly welcome that. But again, I'll plug our fintech at sec.gov box as well. And I think I want to open it up at this point. We're going to switch gears, but does anyone have questions for Zach? Oh, got a lot of hands, Zach. So I don't know if you can hear the question, Zach, but the question was, is Reg S on your radar?
Reg S, as in Sam?
As in Sam.
Is it on my radar? I mean, it's not something I deal with every day, but the guy down the hall does. But yeah, I know it. It's certainly out there. If you want to talk, should I quickly just mention Reg S? Is that helpful? Or?
Sure. That would be great.
Okay, yeah. I mean, so basically, the basic idea with Reg S is that the securities laws don't necessarily specify have a territorial bound, right? Other than that, the requirement that the use of the interstate commerce or the mails, in particular, I'm talking about Section 5 of the Securities Act, which deals with the registration requirement for offers and sales. So the territorial reach, there was some uncertainty as to the territorial reach of Section 5 of the Securities Act. In order to sort of help address that, the Commission adopted Regulation S, as in Sam, which includes two safe harbors, an issuer safe harbor and a resale safe harbor. And those safe harbors describe the conditions under which the Commission will deem offers and sales to have occurred outside of the U.S. and so therefore not be subject to Section 5's registration requirements. And that's the basic premise between Regulation S. The safe harbors are not exclusive. So if you don't comply with them, that's not the only way to prove that the offering took place outside of the U.S. And they're not intended to create a presumption that a transaction that fails to meet the terms of Reg S is therefore subject to Section 5. And this is generally true with any exemption. The burden of proof of compliance with an exemption, to the extent you're claiming it rests first with the person or the entity claiming it. So this is why safe harbors are so helpful, because you don't really need to, if you see what you have to do in order for us to leave you alone, then it's easiest just to do that. And then if post hoc to say, oh, well, we did exactly these things. And then it's proof enough that you've complied with the safe harbors. The two general conditions for Reg S that apply equally to the issuer and resale safe harbors are that the offer and sale must be made in an offshore transaction. It's a defined term in the rules. And Reg S is written in, I know the person who wrote it, but it's sort of a little bit archaic sometimes, so it can be hard to digest. But basically, among other things, the issuer can't make offers and sales to any person in the U.S. That's any person in the U.S. or target U.S. citizens abroad. And there's some other triggers in the offshore transaction definition. The second major prong is that there can't be any directed selling efforts made in the United States. And so along with that, I mean, that's similar to the prohibition on general solicitation you have under 506B, but there's guidance on the practical implications of how that relates to the internet and those types of things. But that's Reg S in a nutshell. As I said, we have our Office of International Corporation Finance, so OICF, is ready and available to answer questions on that. They do that on a routine basis. And there's guidance, of course, online as to some of this stuff. I should plug just generally, our website is loaded with information, and it's very useful to navigate it. And we recently, actually yesterday, we have a new small business page that's up, and a lot of what I'm talking about is on there as well. So you can download and print a nifty one-page exemption chart, so you can sort of see these things lined up next to each other and make X's where needed, where they don't apply, or put checks and figure out which is going to be the best thing for you to pursue.
I know we had a lot of other hands. Okay.
Hey, Zach, my name is Kurt Kumar.
Hi, Kurt.
Just wanted to get your personal opinion. Why wouldn't SEC go something like this? Say, hey, 2 years moratorium, you guys go do whatever you guys want to do. Build everything you want to build. And the only catch is you'll have to just tell us exactly what you're doing. And here's the website, list everything you're doing, and we'll look at it. No lawyers, no intermediaries. We'll just look at what you're doing and we'll tell you, don't do this, and then everybody else behind you should also not do that. And then 2 years later, just say, hey, this worked, this didn't work, and here are the rules, and boom, we are done. No intermediaries, no lawyers.
Sounds like utopia. That's pretty wild. Yeah.
Can I ask a quick question? In this hypothetical, who all is buying? Are there investors?
Well, it doesn't matter. I mean, this is power to the people. You're disintermediating. You don't need an intermediary sitting in between and saying, hey, you can't do this, you can't do that. If you have an 18-year-old who can go fight a war, let him buy a token, And if he burns his hand, I mean, just tell him, like, hey, it's only $200. Don't put your life savings into it. If you're going to put your life savings into it, then you should be getting burned, And it's like, come on.
Yeah. I mean,
you want your gene pool to, evolve. You don't want the gene pool to evolve.
Kurt, I think the concern is taken, right? I mean, that's one prong of our mission. It's not every prong of our mission. The securities laws at their heart, which is what Scott talked about at the beginning, are about disclosure, and it's not about getting in the way of you to raise capital to do what you're trying to do. It's really at its heart. I mean, this is the truth. It's about providing your investors, the people who are buying whatever it is you're selling, the information they need to make an informed investment decision. It's not about saying you can't do it, Kurt. It's about saying, if you're going to do it, tell these people X, Y, and Z to the extent it's material, and these are your options. This is the amount you can raise, and there's certain buckets, of course. So it's not as simple as all that, but at its heart, that's really what we're saying, is that we don't want to get in the way. We're not, as Scott said, we're not merit regulators. We're not saying this is a good idea, this is a bad idea, these are good people or bad people. It's about, look, tell the people what they need, what in general, tell them about your company, and let them decide whether or not they want to invest. The disintermediation, I have no issues with disintermediation, but we're not an intermediary, the SEC. We're just making sure we exist to make sure that people are told the things that are helpful to them, to make sure that they can go out as an 18-year-old and buy what they want to buy.
So Zach, just a quick comment there. If I was a developer today, I can go out and build an app without any rules or regulations that I need to follow through. But if I'm a crypto developer or a founder and I need to do an ICO, today the rough cost is roughly $500,000, and majority of that cost goes into legal guidance and tax mitigation counseling, right? That has never happened in any of the other applications.
Right? Legal guidance isn't an SEC requirement. We have rules. I mean, the legal guidance is there to help you navigate the rules, but the rules are the rules. You're welcome to read them yourself.
Right.
They're there for you to digest.
All right. Thanks, Zach.
Yeah. But your
Hey,
point's
Zach.
not lost on me.
Hey, Zach, this is Ronan here. You mentioned a lot about the Reg A+. We actually have been researching it, trying for a few different projects, and I think many people are promoting this Reg A+, but they don't really tell what's the limitation of it. From a blockchain and token perspective, you have this, from a Reg A perspective, you have this float of $75 million. So you can raise up to 50 million, but once your valuation goes over 75 million, then you have to cap the amount of investors that you have, and special the amount of unaccredited investors that you have. So then in order to comply with that, you need to go through a transfer agent. And then, so what's the point of having a token?
Well, okay, yeah, no, fair enough. What you're referring to is Section 12G of the Exchange Act, which is a different Securities Act. And the way Section 12G came about was back in the 60s, there were a lot of companies that had huge market shares. A lot of assets in the companies, a lot of people holding the securities, but no information out there. And so Section 12G was adopted to say, listen, if you have a bunch of holders of securities and you have a certain amount of assets as a company, you need to register. You need to start providing these people with information, and so you need to register the securities with us. That's what 12G does. It's just a fundamental investor protection. What Reg A does is says, okay, 12G is still there; it still exists. But if you are a Reg A company and you achieve a certain public float, then you have a conditional exemption from having to worry about Section 12G. And the exemption is pretty straightforward. It's just saying, make sure you still file those. Remember those reports you said you were going to file when you did the offering, when you qualified it? Well, we want to make sure you're still filing those reports. So a condition to relying on the exemption, to not having to register the class of securities with us, is that you have to keep filing the reports. A second condition is that you do have to engage the services of a registered transfer agent to monitor the transfers of securities, as you would have had were there were no 12G exemption. So if there is no 12G exemption, you have to get a registered transfer agent anyway, because you're going to have to register the class of securities. So all we're saying is that may be too onerous in and of itself. So just get the transfer agent and don't register, and just make sure you file the reports. The other thing is the conditional exemption lasts for 2 years after you trigger it. And that's a determination you make at the end of every year. So you have, there is a 2-year drag between the time in which you trigger 12G potentially, right? And then you have to comply with the exemption, the conditional exemption, to avoid that. Or you have 2 years in which you have to register. So a lot can happen in 2 years.
Yeah, I guess that's very specific for security tokens that are emerging now. But utilities has a little bit different approach to it.
But your basic point was a concern about registering on a 12G, and what I'm saying is that you don't have to worry about that. You wouldn't have to worry about that on the one hand if you don't want to comply with the exemption for 2 years, and but you can also comply with the exemption, conditional exemption, and avoid it altogether.
Sounds good. Thank you.
Hey, so I have 2 questions. First of all, a lot of the regulations you mentioned. It includes not allowing for the tokens or whatever issuance to be transferred, at least for some point after the sale. When you issue a token, it can always be transferred. And there's centralized foreign exchanges and also decentralized exchanges. So, basically there's no way of limiting if it can be sold after the sale. How do you want to approach that?
Well, we have the set of rules we have. And so, yes, there are going to be tension points to the extent that technology, like the ones you're talking about, are starting to interact with it. As I said before, registered securities, no issue with transferability. Regulation A securities, no issue with transferability. Reg D offerings, regulation crowdfunding offerings, yes, you do have restrictions on resales. Those resales restrictions typically last for private companies up to about a year, or 1 year. And there are ways in which there is a new exemption that under Section 4A7 of the Securities Act for private placements, which allows you to transfer those securities among accredited investors. It's not a cure-all for the concerns you're raising, certainly. But you do have liquidity options with respect to your accredited investors. In regulation crowdfunding offerings, you can resell your securities back to the company within a year. You can sell those securities to accredited investors within a year. And then the third option, which isn't necessarily viable for this crowd, but you can also do tag along of those securities in a registered deal. So Yeah, but there's definitely tension points within the resale. That's not exclusive to this market, though.
And I actually just have a question, follow up on that one. To the best of my knowledge, you maybe no tokens that have been issued thus far have that restriction, but it seems to me that that's something that could be coded in, and or there could be where the tokens go could be effectively an escrow agent, holding for a certain period of time.
There are ways to code it in, but with blockchain, there's always a way around it. So essentially, you can code it into the initial smart contract, and then you create a smart contract, which is a proxy contract, to allow someone to transfer that ownership. I'm mentioning it because there's just going to be some legitimate problems with the technology and regulating it. I think there's going to have to be a new set of laws and approaches to it.
I have a very simple question. If I denominate my shares in some kind of commodity, units of commodity, and I offer them for exchange for kilograms of pork bellies or something, am I out of the radar with the SEC?
Wait, sorry, can you ask that question again?
I denominate my shares in units of some commodity, and I offer them for exchange for that commodity. I am violating one of the tenets of the Howey test. Am I out of the radar with the SEC?
Well, I mean, I would say that it doesn't really matter if it's a pork belly or an orange grove in the famous case. Security is sort of flies above and beyond all of that. So
it has to be in an offer of sale for money. I mean, an investment for money, of money.
I'm sorry. You're asking about what is money for the test? Is that really the question?
Yeah.
The question is very simple. I'm offering shares in exchange for some unit of commodity.
Yeah,
That's
the
all.
test
I don't know
based,
how you want to translate that into money or not.
Investment money problem.
money is not dollars. It's not limited to dollars.
Right.
Well, money has certain characteristics, I suppose. If it's
No, what
pork
I'm saying
belly,
is-
you cannot really call it money.
Yeah.
Anything of value can be anything of value.
Right. I think do you want to take that?
Yeah, I mean, I agree with Zach. It's not limited to currency. The Dow report specifically addressed whether the transfer of Bitcoin would satisfy that part of the Howey test, and the SEC's position is that it does. And so if I understand your hypothetical, you're saying, well, what if it's not U.S. currency, or it's not a virtual currency? What if it's a hard asset or a commodity? And I think our position is that the transfer of money would include that because it contains a value.
Yeah, I think actually Howey and its progeny have quite a bit of there are a number of different examples of what constitutes money for the purposes of that prong.
So my question is, you can actually apply a static value to a dollar or to any fiat. The problem with Bitcoin would be the tax is not going to be collected in Bitcoin, right? So if you have to take the value of any cryptocurrency and apply a tax valuation to it, it has to be in terms of that cryptocurrency, correct? Because if I earn in dollars and it's of some value, it is the number of dollars. If I'm going to pay a tax on it, it's going to be with dollars. Similarly, with any other currency.
Just to clarify, we're not the IRS.
I understand. I understand. But these are closely tied, right? I mean, so, okay. What I'm trying to say is that anything of value is fine as long as the value is static. Anything of value, while it's highly volatile, I don't know. I don't know if everyone has the same question.
I don't know that this question belongs with the
okay.
staff of the SEC. I think you could
No,
probably
I think-
talk to the hedge fund and VC guys up front about how they do valuation.
No, and I think also, to your point, there are a number of different scenarios that we sort of puzzle through, but it's really facts and circumstances based. And so you can call something, I wanted to make a point, at some point during the panel, so I guess I'll make it now. You could call something a tomato coin or a widget coin, but we're going to or a utility coin, but we're going to take a look at the characteristics, kind of at the end of the day and do our analysis. So anyway, that's...
So what can you tell us about the what can you tell us about utility
the characteristics
tokens?
are really just what we've talked about, just the characteristics that would define what an investment contract is. So the Howey test, the types of characteristics and analysis that we put forth in the Dow report.
So what can you tell us about your thinking regarding utility tokens, particularly when they are truly consumptive?
Again, I don't think we've put out anything publicly at the SEC in terms of our viewpoint. We do have the Dow report that I would, commend to you if you haven't read it already. But again, it's really a facts and circumstances based analysis.
It seems like both the current chief and the last chief of the SEC have, in unscripted comments, sort of gutted the idea of a utility token by saying that they've never seen one that isn't a security. So just what's your unscripted thoughts about
well,
utility
none of us
tokens?
on the panel are the chairman.
Right.
So
or the ex-chairman who said the same thing earlier
Yeah,
this
no,
week.
and I think Zach also mentioned to us today that I think Bill Hinman, who's the head of corporation finance, the division that Zach is part of, made similar remarks. Again, I think we're all taking in feedback and information. We haven't put out specific guidance, at least from a policy perspective, as of yet. But I can tell you from where we sit, we very much look at the facts and circumstances, I think, of each of the, the assets or products that we're looking at.
I think we appreciate your more measured, unscripted comments than what we've seen in the by the ex-chief. Thanks.
Yeah.
I have a question here. So what is SEC's opinion on SAFT, this new SAFT instrument? Do you have any opinion on that?
Scott, so SAFT, just so you know, we recently issued an investor alert for people to look at with respect to safes, which is a similar type of security, simple agreement for future equity as opposed to simple agreement for future tokens. If you just consider a token for purposes of argument, right, for purposes of our panel, to be a security, not saying that's going to always be the case, as Kristen said, but if you assume that's the case, then the investor alert should largely be applicable in this space as well. And we issued one, FINRA has issued another one, and you can look at those on our website. We have an Office of Investor Education and Advocacy who issues these types of things. And if you go to our website, you can find the alert, and it can sort of walk you through some of the concerns. These things aren't new necessarily, but you're seeing them being offered to new types of people that may not appreciate all of the things that others may. The same reason we have limitations on who you can sell to in a private placement versus other types of exemptions like Regulation A has a lot to do with the information you're provided. And the investors that are provided. And so that's kind of the driving concern here, is not making an opinion as to the merits of these types of things, but just letting people know that they need to maybe focus on some certain things that they wouldn't otherwise when you see these types of things.
So hello, and thanks for talking to us. Earlier at the beginning of the talk, you mentioned that exchanges are going to need to register. And my question is relating to these new set of technologies which allow decentralized exchange, whereby there is no counterparty, there is no custodian in that exchange, it's just peer-to-peer. Can you comment on that at all?
I guess in your scenario, someone's raised money to create a token exchange, but no one knows who it is, or there's someone behind it, right? Who initiated the project.
So in this scenario, you could have someone who allows buyers and sellers to connect on a website, but they're never acting as a custodian for the actual trading that's happening. It's just people trading peer-to-peer.
Yeah, unfortunately, we don't have enough time to go into the deep dive of exchanges, exemptions, broker-dealers, and so on. But having said that, the custody component is not the determining factor of whether or not something constitutes an exchange.
Would you recommend any resources for learning more about what regulations might apply?
No, I think that would be covered at our Division of Trading and Markets. And so they also have a web page with FAQs and other information, just kind of walking through the analysis of what might constitute, acting as an exchange. We'll also be around. I know that we're kind of what's separating you from the break. And so if we'll be around during the break, I don't know if the panelists wanted to make any last points before we took our break.
I mean, the only point I would make is that in looking at some of these ICOs, I try to apply the Howey test to what I'm looking at, and sometimes, and I think one of the earlier panels called it, like, don't try to be too cute. I mean, if you're raising money and part of your pitch is you're going to be able to participate in the upside of the project financially, but then you think, well, but let's just call it something else, or break it up so it's not as obvious. Those things maybe won't work, and those are might be problematic under the Howey test, because it's really a flexible idea, trying to get to sort of the crux of the issue, which is as I just stated. But it looks at the substance over the form. So calling things differently or separating it all out so it's hard to see sort of the economic substance of what's actually happened, it might not work.
What are your thoughts on the SAFT and whether it can convert from a security to being not a security?
Yeah, I think
we have people are looking. All these types of issues are being digested internally, and I don't know that there's any formal guidance on any of this. I've heard from people mentioning that before, the potential that you have a security in the near term and something that then it turns into something that's not a security later, to the extent the token sort of has a life of its own and a utility outside of its development. Those are all good questions. I mean, frankly, they are. And all the questions you've raised today are good. And I certainly don't mean to be flippant or dismissive of any of them, because they're all legitimate questions coming from a good place. As we said over and over again, we're at an intake stage on a lot of this. And you should communicate with us. You should also reach out to counsel who navigate these issues on a daily basis, because one of our missions is to facilitate capital formation, and that's very much in the Office of Small Business Policy what we focus on as well. So I don't have a good answer for you other than that these are a lot of people are working on these issues internally.
Along those lines, do you want to just touch on what the no action process is?
Sure. The no action process is basically, a no action letter is basically a letter that is issued by the Division of Corporation Finance based on certain facts presented to it from a company, say, that the no action is basically the Division of Corporation Finance telling the Division of Enforcement that we would not recommend any enforcement action on the back of the facts presented to us. If a company is relying on these specific facts, we would not recommend an action. It is very much the exception and not the rule to get no action letters. It's a fact intensive and a resource intensive exercise typically. And I don't know what form ultimately guidance, if any, is issued, when it's issued, what form it will take. It may very well take the form of a no action letter. It may not. It may just be commission guidance. And I don't have a divining rod into any the sense of what the outcome would be, other than to say again that people are thinking about the issue. But there is a process, yes, in Court Fin where you can reach out to our Office of Chief Counsel, for example, and request a no action letter. There may be letters out there that address your situation already. There are letters out there, but the specifics to tokens still at an intake stage. I don't know what form it'll take.
Hello, a question here. Okay, so this is a stupid question with a big implication. What specific properties of baseball cards and baseball card trading makes it not a security, especially where there's a secondary market with exchanges, including fungibility?
Zach, you have 3 seconds.
Yeah. No, this is something, I'm not going to lie. This is something I struggle with sometimes myself. I know a good question is, what about a ticket to a baseball game? And then suddenly everyone wants to go and you can sell it on StubHub and make a profit. Why isn't that a security? And because there's a game, there's a thing that's going to happen, then it's going to go away. But fair point. As I said before, what is and isn't a security is a very fact-intensive exercise. That has typically not been regarded as a security, although I'm sure there are people who may be more aggressive in their interpretation of what is a security, and for them, maybe they would look at it but say, hey, the ship has already sailed on baseball cards.
I have a quick question that's very related to that one, which is it possible for a token that trades on an exchange to be considered by the SEC to be a utility token and not a security? Or does the act of listing it on an exchange make it a security?
Well, yeah, okay, sorry, go ahead, Kristen.
Oh, I was just going to say, no, I think it still depends upon the character of the investment. It's not just because something's listed or somebody registers that they're necessarily subject to the SEC's rules and regulations. We'll still look at, sorry there.
Is that Sorry, we're having
so
a technical glitch.
short answer, no, yeah.
I was wondering, to what extent is the SEC exploring regulation with protocols instead of legislation, and what properties would you want to see from such a protocol, regardless of whether, would you want an example? Am I being too abstract?
I think that'd be helpful. Yeah.
So, let's say you want to achieve a goal of regulating that tokens launch at whatever their market value is. So this is something that I recently explored in a paper with Vitalik Buterin and Christopher Brown, and we basically want to. So I mean, it was basically a reaction against some of the concerns people had with cap sales and uncapped sales, where either you don't know what valuation you're going to get, or you don't know that you're going to get to participate. So it's either one or the other. So in other words, let's say we don't like cap sales because they're people don't get to participate. So maybe your goal is to let people participate and also let them know what the valuation is. So I'm talking about this as a specific problem we looked at. But so we came up with a protocol that actually runs in a smart contract that gets people so they can put money in and take money out, so that it should eventually converge to the true market valuation, if you will. And so it's some sort of, I like to think of it as like a self-regulating procedure, but I don't know if it's a regulatory tool or not, but I just wanted to throw it out there and see what you guys think about this. Is that a direction you want to go?
Yeah,
that one I think we'll give some thought, we really appreciate the engagement. We do, and we'll stick around. We'll be around for the next 40 minutes or so. To echo Zach's point, and I think the other points hopefully that came through on the panel, we really welcome your feedback. This is a new and emerging area for all of us, and so I think we're trying to be very thoughtful and deliberative in terms of the advice that we give, the guidance we give. And we'd encourage you to, contact us in different ways. I think writing into the fintech@sec.gov mailbox. You can also contact the policy divisions to seek no action relief. I think that Zach mentioned. There are resources available on our website. And again, thank you so much for all the fantastic engagement.
Thank you.